Well, welcome everybody to this DPN network event, Privacy Question Time 2024. We've got a large number of attendees registered for today, and as I'm just talking, I can see everybody logging on. So I will talk slowly as people arrive. Before we get into the question and answers, and indeed polling questions that we will also be dropping in, I wanted to introduce the panel for today. So I'll start with me, Robert Bond. I'm Senior Counsel with Privacy Partnership Law in London. I'm also an Industry Commissioner at the Data and Marketing Commission. And probably like you, I am closely following the DUA bill, which I understand is shortly, well, will have its third reading in the Lords before we get to Christmas. And we'll be talking about the DUA bill because a number of you have raised questions on that. Can I now introduce our first panelist, Fedelma?
Many thanks, Robert. My name is Fedelma Good. I'm a freelance data protection and ePrivacy consultant. I, like Robert, was previously a data protection commissioner and formerly sat on the board at the DMA. So I am very pleased to be here today, particularly with colleagues from the Data Protection Network.
Thank you, Fedelma. And Chris, can you introduce yourself?
Absolutely. Good afternoon, everyone. I'm Chris Whitewood, the Privacy Data Protection Officer for Direct Line Group. I've been in role about 7 years now, and I'm not a data protection commissioner, but there's still time.
Fabulous. And finally, Simon.
Yes, thank you very much, Robert. Thanks, Fedelma and Chris, for joining us today as well. So I'm partner at DPN Associates, obviously putting on the event today. For anyone who's not been with us before on these kind of events where we've done webinars and other kind of events in person as well, so you know a little bit about DPN. We're a thought leadership network. We publish lots of information, including we've just published some guidance on legitimate interests, our third version that's just gone live the last few days, if anyone's interested in reading that. But equally, we work with lots of clients across all different sectors, UK, Europe, and around the world, in fact. So, yeah, it's a little bit about us.
Thank you, Simon. So let's move on. We've had, as I say, a lot of questions sent in, and thank you to everybody for those. By all means, you can ask questions using the chat box as we go along, and I'll keep an eye open on those. We've selected a number of questions, firstly covering the DUA LEPA bill, then governance and accountability, then AI, cookie rules, and DSARs. Before we start the questions on the DUA bill, I wonder, Simon, if we could do the first poll, which please
Sure,
be
yeah.
Great if you attendees could answer the poll, which will come up shortly.
Here we go.
And
So,
on the right-hand side, there is a poll icon which you can use. And the poll is, are you broadly in favour of the proposals in the DUA bill? And I'm watching people voting as I'm talking, and we don't yet have anybody that says I'm not in favour. I think this vast majority appear to be in part in favour. that doesn't surprise me because it's a monstrous piece of work. It's very difficult to analyze. So I think everybody's waiting for some clarity. So I think we're pretty much done here, Simon.
Yeah. I'll just end.
So 20% say yes, 39% say in part, nobody says no, and equally 39% of you are not sure. I think that is a fair reflection. Okay. So yeah, let's take the first question. For those of you that have analysed the Dewar Bill or seen commentary on it, you'll be aware that it is a variation on previous themes from the Digital Information and Smart Data Bill, what the Conservatives were previously proposing. One of the questions we've had, and ladies first, I'll put this to you, Fedelma. What changes are specifically proposed to our UK law, GDPR and Data Protection Act? Are previous changes to DPOs, ROPAs, etc., still included or not?
So some are in and some are out. So the change in respect of the DPOs, that has gone away. There is no replacement of the DPO role with a senior responsible individual, which I have to say I am particularly pleased about, because for me, the concept of introducing this title of senior responsible individual, when you were used to the concept of accountability, and for those who work in large organizations and who know there's a distinct difference between responsible and accountability, it always seemed to me to be a strange inclusion. So that one, very pleased to see it was gone. And in the context of ROPAs, sorry, what was the specific question there, Robert?
Well, in the last bill, there was suggestions that ROPAs would not necessarily be needed anymore.
Well, thankfully, common sense has prevailed. If anything that we have all learnt, and in fact, in recent newspaper articles specific to AI, the forerunner of everything is understanding the data that you hold. So thankfully, we're seeing the common sense elements there. Yeah.
Good.
Prevail.
Good. And Chris, any comments for you on that question?
I think it's a common sense approach. I think the controversial elements have been removed from the bill. I don't think anyone really understood why the government previously wanted to amend DPIAs, which are the cornerstone of a good privacy programme. And as Fedelma said, the position not to replace DPOs is very welcome, not from a purely selfish point of view, but also from just defining who's responsible and accountable within an organisation for privacy and having that really clear RACI across the business.
Okay, I'm going to move on and I'm going to put this question to you, Simon, first. So again, there's much more of a focus in the bill, and indeed there was in the last version, on the value of legitimate interests as a lawful ground. What does the proposal for recognised legitimate interests mean in practice?
Yeah, thank you, Robert. Yeah, it's an interesting one, and it was something that was discussed in the previous bill as well, this whole concept of what should be a recognised legitimate interest. Well, this is effectively saying that certain types of processing activity can be done automatically, effectively with legitimate interest, without you having to carry out a full detailed assessment. So effectively, we're looking at things that are things like national security, emergency response. And if you can think of services like emergency response, there can be some challenges if you have to complete a legitimate interest assessment prior to actually doing emergency activity. So you can see some issues there, equally with safeguarding, which is another area. So they're looking to make those recognised legitimate interests, to say that actually in those sorts of situations, you don't have to carry out a legitimate interest. However, there has been some debate about various other areas that might be considered recognised, and actually I think it's a relatively short list. And I think that's important because there are many other areas. There's been some discussion about, for example, certain marketing activity. And it's been clear that, and I think the DMA have very much backed this, that actually it is appropriate to be carrying out a legitimate interest assessment, because you need to understand the impact on the rights and the freedoms and the interests of the individual. And that's why legitimate interests is all founded on, really, is understanding, what are the rights and the freedoms and the interests of the individual, and whether those are overriding of the objectives of the organisation and the processing that the organisation wants to carry out. So I think it's been handled in quite a balanced way, to say that there are certain responsibilities that can be recognised and you don't need to do the assessment. Apologies if there's any feedback. I'm hearing a little bit of noise here. Apologies if there is, but it's very clear that you'll still have to carry out an assessment, a documented formal assessment in the way that you would in most other situations. I've lost you, Robert. I think you're off mic.
And in the previous draft bill, there was the suggestion that we wouldn't need to do DPIAs except in very high-risk situations. And I think it's very encouraging that we are moving back to realizing that risk assessments are a valuable tool across the entire data governance area, particularly now we've got AI as well as transfer risk assessments and cyber resilience and so on. Anyway, shifting gear, one of the other proposals is a formal complaints procedure. Fedelma, what's the significance of this bill introducing a formal complaints procedure, please?
Well, what it will do is have quite a broad impact on organisations, because at the moment the requirement is that you need to call out to individuals that if they are not happy with how an organisation is dealing with their personal data, that they can raise a complaint to the ICO. This inverts that process and says that you must go to the organisation first before going to the ICO. So if you think about the scope of operational impact, this will mean a change to privacy notice. It will require a change in the training and guidance that you provide to your frontline staff. It will also require different processes to enable you to be able to record complaints. And I suspect Chris may well be able to come in here with some added value in the context of that issue about how challenging it is for organizations when they get a complaint in to actually record and deal with it. So maybe I'd pass over to you, Chris, for that one.
Yeah, sure, no problem. So I think one colleague of mine cynically said it was the ICO trying to get out of doing some work, but I won't name names on that one. But I think the complaints issue is something, and it depends on your size of your organisation as to how big the impact will be. As a financial services firm, we have FCA obligations in respect to how we record complaints, so it's not going to be too much of an operational difference anyway. And part of having a good privacy program is understanding those data protection complaints and reacting to them. I think what the bill will also make us do, and there are powers for the Secretary of State to actually mandate reporting to the ICO, is really challenge some organisations as to how you distinguish what a complaint is, and does it relate to data protection, and does it fall under this process. So that might need a bit more conversations with your customer relation areas to really say, well, what is the nub of this complaint? Is it saying, okay, my price is too high, but it's based on inaccurate data? Is that a data protection complaint, or would that be categorized as a pricing complaint? So there's quite a few things to think about as to how you can actually make that distinction and get the reporting off the back end to make sure you really understand what issues are coming through your business. But it makes sense, and I think most companies will have some form of reviewing complaints, but it puts it on a more formal footing.
Thank you. Simon, one of the other questions we've had is, does the bill propose to bring PECA fines in line with GDPR? What's the current position? You're on mute.
Apologies, I was doing that because I had a little bit of feedback last time, so sorry everyone. So we're talking here about the privacy and electronic communications regulations, in case anyone's not familiar with PECA. So currently the fines under PECA, and have always been, actually capped at £500,000. So a very different kind of level to GDPR, which is up to 20 million euros, or around about 17 million pounds. So a different scale. And yes, the bills are actually proposing to bring PECA in line with GDPR. So the impact is that actually that makes it a lot more serious. Actually, a PECA infringement could be a lot more serious, and particularly because, certainly looking at the way that the ICO has tackled this in the past, they've been looking very much at activities where there's things like spam text messages or emails and things like that. And so the situation in those is that we could be seeing some significantly higher fines in those areas, but equally for other kinds of infringements as well. And there's another area kind of associated with this, is that also not only the fines could be significantly higher. Obviously, we've got quite a proportionate regulator here as well that will not always, automatically go to the highest level. That will consider it in the light of what the offence actually is. But from the point of view of understanding what could happen, the fines could be a lot higher. And equally, they can consider the volume as well of those messages that didn't actually land with an individual. So some of the situations that we've been dealing with in the past, where spam text messages or emails have been sent out by organisations, a number of those obviously have gone to older databases that have not actually landed with individuals. So therefore, the scale of the fine that they could impose was actually based on what was delivered rather than what was sent. This enables the ICO therefore to put larger fines where an organisation maybe has used older data, or particularly has sent out very large volume campaigns. It enables those fines to be aligned to the scale of the activity rather than the scale of how much impact that actually had on individuals.
Okay, thank you, Simon. Fedelma, there's another question I think I'll put to you. So one other aspect of the use and the DUA bill is there's a whole section on so-called smart data. Can you explain what that's all about, why it's there, and so on, please? And you're on mute.
We're all at it. We're all at it. So this smart data focus is about giving the DCIT and HMT, the Science and Technology Secretary and Treasury, the power to introduce new smart data schemes. And what these will be about is creating the right conditions to support individuals being in control of sharing their personal data with regulated and authorized third parties. And it's akin to what we have seen in open banking and my data. And in open banking, we have seen the possibility that you can actually, through one financial services regulator, actually take input from other organizations who you have money or investments with, so that you can get a single central view of everything that is happening. And we've also seen it deliver benefit in the current account switching process. So what the smart data provisions are basically setting about provisions to allow people to reuse their personal data, and rather than it just being what we see in GDPR, which is the portability, you can request your data in a reusable format through portability. Smart data goes one step further and allows you to ask your data to be directly shared with another third party. And what it will also seek to do is put a supporting framework in place to ensure data security where those sorts of sharing processes are put in place. And one of the areas where they've tried to do this subsequent to the open banking was in the utility space, so that you could get competitive pricing for electricity, gas, and other utility provision. So what it's seeking to do basically is move this on and really get it into, if you like, the next wave of data sharing, but through a process driven by the government.
And I was just going to add that in the EU, there's the Data Act, which comes into force in September 25, which is the same, it's an equivalent process where any manufacturer or distributor and user of smart devices, connected devices, including, you know, down to your printer and scanner, will have that same right of access and control over their information, and government will be able to have the same access. It's going to put quite a lot of pressure on technology companies to consider how they protect their metadata, their proprietary rights in products when individuals will be able to have access. And I think you mentioned GDPR and portability, Fedelma. We've not really seen people exercising their right of portability, but I think we will see more of that as this goes forward. Okay, thank you. What do you think, Chris, is the biggest issue for you in the DUA bill?
I wouldn't say a particularly things are an issue. I think I'd probably welcome most of the changes, particularly where we were with the data protection and digital information bill. So I think for me it's very encouraging. I think the complaints issue will require a bit of work. I think the cookies angle, I think, welcome again, but that will also necessitate reviewing what cookies we implement across our websites, and then how can we make sure that what consent is needed in line with those provisions. So I don't envisage it to be causing too many practical issues off the back of it. I think it's just a case now of how everything from a regulatory perspective hangs together for me, particularly if the government are looking at introducing new AI legislation as well.
And you don't think we will lose our adequacy if the bill becomes law?
No, I don't think so. I mean, I think we're so closely aligned. I mean, the automated decisions is probably a slight out of step with the EU GDPR as it is. But I don't think the provisions are going to go far enough to have a challenge from Europe on that. And if the US can maintain the data bridge with Europe, I'm pretty sure the UK can. And I think politically there's just not the appetite there from either side to rock the status quo at this moment. Yeah,
I'd agree with you. Okay, let's change to the next topic, which is governance and accountability. There's been quite a lot of talk about the so-called 3 lines of defense when trying to manage data risk in an organization. Simon, what's your experience of how the 3 lines of defense is being used, or is it most companies behind the curve on this? What's your view?
I think to be honest, I think it varies enormously by sector, by size of organisation. But I think certainly see a lot of value in having a 3 lines of defence approach. And for those that are not familiar with it, maybe it's worth just explaining some of the kind of the basic principles of it. It's about it's really a risk management process or framework to make sure that risk is is well understood across the business, and you've got the right roles, responsibilities, and processes in place to handle risk. So looking at the 3 different lines, the first line is the activity and risk owners, i.e. the operations, the operational functions like marketing and operations, people management, all of those different frontline functions, we might say, that effectively become risk owners for the processing activities that they carry out. So how they handle the data that they process in their teams, and they will have responsibility for that. And in fact, as Fedelma says, we're talking actually about accountability for that, which means not only for using the data, but making sure that the measures and protections and controls that they've got in place, be they people related, be they technology related, are protected. But equally, to do that and fully understand the law, they need specialist advisors. So the second line effectively are teams like the data protection officer, the risk team, information security, IT for that matter, legal compliance, those types of kind of risk related, but particularly their role is to act as specialist advisors to those teams to make sure that they're well advised of the law and to help them make sure that they understand and that they've got the appropriate measures and controls in place to protect it. And then the third line is effectively an assurance function, like an audit function of that, to make sure that that whole process is working seamlessly and that there's regular reviews of the process and report that back in an independent way to the executive team. So that's how it should work. There are slightly different flavors of it, by the way. You can look on 5 different websites to explain what 3 lines of defense are, and you'll get 5 slightly different explanations. So I've tried to give you a broad brush approach to how it's typically managed. I think when I've seen it work, it can work really well because it can give really nice, clear responsibilities. So when it's built into people's job descriptions, and equally when an organization can live and breathe it, so it's very clear that this function, for example, and these individuals have got specific responsibilities, but equally they've got support to execute those, it can work really well. But to be honest, from my experience, in a number of organizations, it doesn't always operate in an optimal way, in that, for example, some people can have, let's say, slippery shoulders that maybe they feel more responsible than accountable, that they appreciate it, that it kind of stays with, the responsibility kind of sits with them. But the question is whether they've truly got the right measures and controls in place to protect the data. And that's, of course, where monitoring comes in as well. So part of the function of the second line is to be able to monitor the activities of the first line and report that back to the executive, much like we do in a privacy program. How well are we complying in these areas? Where are our weaknesses, and how do we go about tackling them? So I think, as a framework, that's really good. As a methodology, it can be challenging to put that in place, to make sure it's in people's job descriptions and make sure that it's well understood across the business, and to just get people living and breathing it and using it regularly across a business can be a little more challenging, particularly, I guess, for smaller organizations or for those that are not in regulated sectors, perhaps, where this type of activity doesn't necessarily come naturally, and needs maybe a little bit more thought about how it would be implemented. Hope that helps. I'm sure others have got some comments to add to that as well. I'm intrigued.
Fedelma?
I think that's a fabulous synopsis, Simon, and I would agree with you. And I think the 3-line model is one that we would certainly be more, it would be more familiar within the larger organizations where those distinct roles, and thresholds, if you like, of responsibility come in. I think also in the 3-line model, when you look specifically at GDPR compliance, one of the challenges can come where there is an intersection between different areas of overlap, if you like, in the law. So if you think about the context of cybersecurity, data protections folk are not typically cyber specialists. And yet we have that issue about technical and organizational measures needing to be put in place to keep the data safe. And that's where I think in organizations where you have a 3-line model, understanding those areas of overlap and building really good relationships, with those other teams where you have, if you like, intersecting and overlapping responsibilities can really make a difference to your 3-line model. The same would be true in the context of data quality. because again, a data protection officer won't be out defining, the accuracy, the technologies that will be used to ensure data accuracy and quality, but they will sure as hell be concerned that it is being achieved. So that's where I've seen, both challenge and some really, really good handshakes being put in place within the 3-line model to really make a difference for the organization.
And anything from your experience, Chris, you want to add?
Yeah, I mean, we have a 3 lines defense model. And I think Simon kind of hit the nail on the head, really. It's about clearly defining roles and responsibilities. And that's not just at an operational level. It also needs to be at a senior management level as well. Having those who's doing what and when really clearly mapped out, so you can actually make some informed decisions without that falling off the back. But it is also about having a really clear roles, responsibilities, and having that embedded across each area, so each area knows exactly what they're doing, where the handoffs are as well. I think the GDPR slightly muddied the waters a little bit with the role of the DPO, where there were some questions about the DPO being accountable for all privacy, which is certainly not how it is. And it's really just making sure from a freelance defense model, your business areas understand the privacy risks that are running. They've got in place ways of adding controls into that, documenting it as well. And then my role more as a DPO is more independent oversight and challenge as part of that model. Again, but you also need the reporting and the MI and the KPIs to back it up as well.
Yeah. Okay. And sort of connected with this is when you look at the regulatory action policy of the ICO, and they talk about what good looks like. If you can show that you are trying to do the right thing, that you have done audits and assessments, that's good. Also, how are you demonstrating accountability? And one of the questions, Simon, was the ICO's recently updated the accountability framework. It's quite a significant process. One of the questions was, is it compulsory for us to go through this?
Okay. Well, first of all, no, it's not compulsory to use that particular framework. However, I must confess I'm a bit of a fan. And that's because it's the one thing that really sums up what the ICO's expectations are in each particular aspect of the law. And I find as a framework, I actually find it really useful. In fact, we use the similar framework in a lot of our client reviews, in that it tells you for any particular area, it really gives you a good understanding of each particular, because regulators didn't always tell you that prior to this framework coming out. It tells you more what does good look like. I think that's important to understand. And as you said, they've recently upgraded it to include AI and children's data as well. So to make particularly for AI, I think it's really good to understand what does good look like from an AI governance point of view. And I'm sure this will evolve and develop further over time. But as you said, it's a pretty hefty item. If you look at the Excel version, it's well over 300 different areas now, which makes it rather huge. So again, I think it's one of those kind of things that certainly in my experience is really maybe used by the larger organizations, again, quite often in regulated sectors. However, I think the principle is very good, and a reminder for smaller organizations, there's still an online version as well, which is much lighter, which can be used. But it is just a gap analysis. So the way that we approached it, we thought it was a very good format itself for conducting reviews, for example. So we've decided to take it on board. We use it as a foundation, as I said, when we do reviews. So we use a lot of the information that's in that to do a gap analysis, and then we build on top of that an action plan and a dashboard for executives as well. So it became a really good foundation for things like that. And I think for other organizations, it can be a great way to at least start your gap analysis, providing you look at the parts and you say, well, which parts are relevant to our organization and how do we prioritize the gathering of this information? Because to do all of the sections in one go might be, for many organizations, might be too big an exercise that might just take too long. So you might wish to prioritize certain areas over others.
Okay, moving on to the next area, which is artificial intelligence. You just talked about AI, Simon. The EU has got an AI Act. We don't yet have legislation, although the Dewar Bill touches on automated decision making. I'm interested, Chris, what do you think, or indeed what do you think, what are you doing in your organization to ensure that the data privacy, data protection team are trained on understanding what is AI, what risks we should be assessing, etc.?
So we've done quite a bit of work on AI. So we've worked very closely with our data science teams and our data governance teams to talk about introduce kind of an AI framework and some AI principles off the back of that. So some of that will cover off new initiatives. So essentially rethinking your DPIA questions to cover AI initiatives, which kind of plugs into what the EU AI Act is talking about in terms of risk assessment. So the risk assessment for AI is key. And then in terms of training, we've actually reached out. We've got a couple of providers on board. So we've got a really good one called Data Camp, which we've got a data academy, which all members of staff are encouraged to do. And they run courses about AI. So it's not just AI, it's also about data literacy as well. So you can have some more informed conversations from a privacy perspective with your colleagues who are developing or seeking to deploy AI across the business. And I think the AI training is really, really important at all levels, not just from a privacy side of it. It also needs to go right to the very top of the organization for your executives and your senior managers. So they really understand what AI is being deployed under their remit, what the risks are, and can then make informed decisions off the back of it. But I think from a privacy side of it, there's external courses you can do. There's the IAPP course, but there's also other providers like IBM. You can get some really good free resources from there as well. But you need to really upskill yourself, I think, as a privacy professional. I think it's one of the challenges, particularly for those of us who are not born programmers, so that we can have those informed conversations across the piece and really have that training that we need.
Okay, thank you for that. There's a question just come in that relates to automated decision making. So in the Dewar Bill, there is a suggestion that there can be more use of automated decision making, particularly for scientific research. I'm interested, Fedelma, do you think that that is a good move, or are we actually not looking after individuals' interests here?
Now, I have to admit that that section of the Dewar Bill is not one that I'm that familiar with, but what I do think is that the residual safeguards that we have, which the bill won't tamper with, will remain in place. So when we look at the intersection of automated decision-making profiling into the AI piece, for me, I believe that what we have, if that people continue to follow the principles and guidelines that are set out there, then we will remain okay. The challenge, I believe, and I am calling on my memory here, is in relation to the special category data. And that is an area where we always have to pay due diligence. And the bit for me in the context of an organization's embracing of AI and sort of that training, that acknowledgement and that understanding and its intersection with automated decision making, it's back again to the things that Chris has articulated. Education. I would go even one level higher than Chris would. I would go to the board. Yeah. The board, if you have one in your organization, really do need to be part of that educational process for you. It's not just your senior leadership team. And in the context of automated decision making, the same principles that we think about, which is what data are you using when you are developing these processes? And in the context of AI, that context of what are you using as your training data, for me, becomes absolutely paramount. And that, I think, is where some of the lack of understanding comes. And some of it is back to the point I was making earlier on about it. We all need to know the data that we are using, the purposes we're using it for, and how and where we can create training data sets that don't necessarily have a negative impact or outcome on the individuals. So I suspect, Robert, I've not given quite a finite answer on that one, but hopefully you can fill in the gaps.
Well, thank you. I think for me, one of the worries I've got is that the language where it says you won't need consent, where you're using sensitive data for the, where you're doing scientific research. The worry is that the wording is quite loose, and it's not research in a science industry. It is science where it's research where there is a science to it. And frankly, any research has an element of science to it. And I worry that it might be allowing, the technology companies, the Google DeepMinds, to be doing way, way more with people's data. Although, there's specific carve-outs in the DUA bill for the NHS and the police to have more ability to do things with people's data. So I think we just have to watch that space. Okay, I'm conscious of time. There's a question come in about cookies. We'll get maybe to that in a minute, but can we do the poll, Simon, for cookies?
Yes, let's do that, Robert. The poll for cookies. Here we go. There you go. So I'll just read it out for you. Do you think that the law should be changed in relation to cookies and similar technologies? That's fairly remarkable. 100% so far.
Yes, there does seem to be a large majority wanting change. Nearly, 75%. Okay, should we close the poll now? So, 75% say yes, we want change, 11% no, 13% not sure. The question that we've had in on this is in relation to whether the DUA bill is proposing changes around the use of third-party cookies, or is it simply to make the cookie pop-ups less onerous than they currently are? Fedelma. And you're going to tell me this is not your area either.
So in the context of cookies, I think we see some retention of some of the original bill's provisions. And for me, the common sense one is around the use of cookies, which are first-party cookies, purely for the performance and improvement of your website, which to me it seems eminently sensible. And we've already seen that some of the other regulators across Europe with the Privacy Directive have gone with similar local implementation, of course, with this RPECR being based on what was a European directive and therefore subject to local deployment. So for me, what we are seeing now in the DUA bill is common sense. What I also think is very interesting, though, is we are seeing much more of a harmonization being brought about between PECR and GDPR. We've heard about the fine levels already, but what we are seeing is the harmonization and the opportunity where industry guidelines can be implemented. And Robert, as a commissioner, you will understand the benefit there immediately to the marketing sector about that. And that, I think, has also been something that the DMA have been seeking to achieve, to bring about basically much more cohesion and consistency and greater clarity. So for me, I welcome what we're seeing in the proposals for change to PECR, a common sense approach, and one which I hope will enable businesses to use the technology much more practically, without any detriment or negative impact on the end user.
Thank you. I think I'm going to suggest we move with roughly 10 or 12 minutes to go to the final poll, which is around data subject access requests. We've got a couple of questions or more on that. Can we bring up the final poll, please, Simon?
There we go.
Have data subject access requests lost their true value? It's quite even at the moment.
I think this is one that would be interesting to hear based on, because it might relate to the experience that an individual's had in their organisation, perhaps more so.
So I think we're probably there if we close the poll, Simon. 33% say yes, DSARs have lost their true value. 48% say in part, and only 18% say no. And I think your point is a good one, that I think it will very much depend how people are seeing DSARs being weaponized, for want of a better word. Chris, what's your view?
Yeah, it is an interesting question. I think I'm slightly in the no camp, a little bit, if I'm being completely honest. Because the DSAR's only got value to the individual who's making it, I think, at the end of the day. And there can be a multitude of rationales as to why you would want to make a DSAR to it. So I think for the person getting the results back at the end of the day, the rights haven't been watered down. I think they're still getting the opportunity to get the data that they want. I think maybe the sort of sour taste in the mouth is how they're being used, which I think you alluded to, Robert, is how sometimes abused, particularly more on sort of your no blame, no claim kind of requests where things are coming in. And I think grievances as well. I think most people probably on the webinar who've had the joy of looking at an employee DSAR will probably share the pain as to how they get organised. Because I think very much so they are linked to grievances or potential role changes. So I'm not sure it's the value. I think it's more the burden on the organisation sometimes, which we kind of get lost at. So from a personal perspective, I don't think they have lost their value. From a DPO perspective, I'm not a big fan, but there we go.
And Fedelma, what do you think?
I would have confused the poll, because I think yes and no. Yeah, I think if we think back to the roots and the objectives of the GDPR, which was to put people in greater control of their data, the fact that we are seeing an increase in DSARs being executed means more and more people are aware of their rights in respect of data. And I think that's fantastic. Where I do think that they have sort of been weaponized, I think that is a real pity. And I think if we measure for larger organizations the number of DSARs that they're getting which are employee versus customer, you would see proportionately, where that weaponization is being used to a certain extent. Again, that might be different by sector. So for me, I definitely sit between that yes and no. I really relish the fact that individuals are certainly far more aware since GDPR has come into play about the rights that they have in respect of their data. But the weaponization, I just feel is such a pity. And for me, one of the things I think there is still an opportunity for how organizations actually convey to individuals the rights about the data and what they will get if they submit a SAR, and actually try and direct them more towards what might be underpinning the request to address it. So really finding some other means by which the request can be executed and satisfied to the individual's satisfaction, but without necessarily all of the back-end processes, which are hugely time-consuming, and I'm not convinced in the end necessarily deliver an outcome or content that the individual will find useful given their situation.
Yeah, and Simon, anything you'd like to add?
Yeah, my views are quite similar to you, actually, Fedelma, and that I very much support the right that individuals should have this to be able to call out organisations, because without knowing how their data is being used, the different ways and how that's all happening, it's very hard for them to challenge organisations. So it's really important principle to have. But I also totally agree that in many situations, they're not being used for the purpose that was originally intended. That is, as you say, a great shame. And I think it might be worth just touching on Duo once more at this point. I don't know if you're going to come on to that or not, Robert, but from the point of view that there are some changes proposed to subject access requests in Duo, particularly to make some of the common practices or practices that are regularly used by organisations go onto a statutory footing. So, for example, the organisations can go out to the individual and ask for clarification to request specific details. That's confirmed in Duo. Also, that they can pause the clock effectively while they're seeking that information from individuals is also a proposal. But one of the more interesting points I wanted to raise, I'd be interested to know what others think of this, is around the search criteria and the search for personal data across the organisation to a DSAR only needs to be reasonable and proportionate.
Yeah,
that's what it says. So I'm interested how that will pan out, to be honest, because what one organisation or one individual might consider reasonable and proportionate might be quite different to another. So I think that's something that we'll have to watch to see what's considered reasonable and proportionate when searching it.
Yeah, I mean, certainly from my experience, I suppose I'm often consulted when things are not good, and we have somebody whose lawyers are using DSAR as a backdoor to discovery, or they are doing it because their client has more money than sense and simply wants to grind a business into the ground. Once the SAR has been dealt with, then there's another SAR and another SAR and then a right of erasure, and it's a business in its own right, I'm afraid. And so I see the worst side of it. So I do think there's an issue there, and I do think it's encouraging if you don't have to make excessive searches. In some instances, we are being told we want you to search in X number of languages and Cyrillic and this, that, and the other. Wow. And it's all intended to use the DSAR to grind a controller into the ground. One more question, I think, before we get to the end. The question is, where a data subject has requested emails, is it okay to contact the people who have those emails in the business and ask them to forward them to the person managing the SAR? Or should the process not involve people holding the emails requested? Fedelma, your thoughts?
My answer to that one, Robert, would be no. This a DSAR request should remain centrally managed, and there would be a number of reasons why I would say that. Firstly, a DSAR request in itself should be treated confidentially. So by going out to other individuals to actually ask for them to provide the information back to the requester, you could be breaching a point of confidentiality. You could argue that you could build in a consent model to say, Simon, are you happy for us to ask Chris to send you that information? But again, there may be other issues within that. There could be other personal or potentially business confidential data within whatever information Chris might share back to Simon. So for me, I would keep it as a centrally managed and reviewed content that would be sent back to the individual.
Thank you. And Chris, anything to add on that?
I think I 100% agree on that front. I think having it centrally logged just makes things a lot easier. It maintains independence as well. And you can always review, is it a third party's personal data anyway, under the exemptions when responding to the request. So, yeah, I'd echo what Fedelma's just said.
So we just got 3 minutes or so to go. So before we finish and I hand over to Simon, Chris, do you have any closing thoughts on the current state we are in? Are we getting easier in the way we manage personal data? Is it more complex? Is it a bigger risk? What are you finding in practice?
I think is it easier? I think yes and no. So I think there's new challenges coming along. So I think AI is probably, everyone's been on an AI webinar or seen some AI presentation. I think there's a lot of challenges there for organizations to think about and how we manage that and make sure that we get the right AI governance in place across the piece and really understand that. And again, I think in the sense of no, we've had GDPR for a number of years now. We've got a base, or most organizations should have a basis fairly well established, and privacy programs maturing or getting into a mature state to enable organizations to manage personal data in a way that's compliant. I mean, there's always going to be interesting things coming up with new technologies which we'll need to react to. But I think provided we keep an eye on the ball, keep an eye on what's coming down the line from the government and regulators, I think we're in a fairly decent place. If you're talking about the world in general, no, we're not in a good place. But
okay, and Fedelma, final thoughts from you.
So for me, I am very pleased to see the DUA bill as it is. I think it approaches changes positively, but much more constructively, and makes our retention of adequacy much more likely. I like the changes that are in train to bring greater harmonization between ePrivacy and GDPR, because for me, I've had a long-held belief that organizations tend to forget about the PECR compliance in relation to cookies, not the e-marketing, but in the cookies. And it's quite helpful now to see these being more harmonized. And overall, the bit that remains for me just a concern is that most conversations are about risk rather than opportunity in the context of data. I hope that with this bill, that the government and other organizations will embrace some of it to try and help with that positive reinforcement that data can be used positively and for all our benefit. But I think we've a way to go.
So we've got about a minute or less. So I'm going to say on behalf of attendees, thank you to Fedelma and Chris and Simon as panelists. It's been good fun. We've enjoyed the questions. I thank you for the questions that have come in live. Apologies if we missed any of those. Looking forward to doing this again sometime, and I'll hand back to you, Simon, just to close us out.
Thank you very much. Thanks, Robert, for ably chairing it, chairing our session today. That was great. Thanks very much to Chris and Fedelma for your very wise words. And also thanks very much to our audience for coming along and submitting some really great questions for us today. I think it's been interesting, and I'm sure many of us will be following DUA quite carefully now over the next few months to see how it progresses. So we'll let you all go now. It's 5 o'clock. And so thanks very much for joining us, and hope to see you all again soon. All right. Take care.
Thanks
Bye.
all.
Bye.
Bye.